Newly introduced Senate Bill 303 aims to allow people 18 to 20 years of age to buy a handgun.
Yeah, but it goes against an already established federal law, potentially making way for a legal fight in front of the Supreme Court. An expert tells me if it goes that far, it does have a good chance of winning. Senate Bill 303 looks to allow a person between the age of 18 and 21 to receive or purchase a handgun from a federally licensed firearms dealer. But it challenges a 1968 federal law that prohibits people under the age of 21 to buy a handgun.
It simply sets itself up for a lawsuit.
Which is exactly what former Ohio Attorney General Mark Dan says Republican lawmakers want.
It sets up a classic conflict between state government and federal government. Somebody will attempt to buy a handgun, be turned down by a federal licensed dealer, and that federal licensed dealer will then potentially be sued by the potential purchaser.
Allowing this bill to have its day in court. This tactic is exactly how Roe v. Wade and civil rights laws in the South were overturned.
That pendulum of states' rights versus federal rights, over the course of history of the U.S. of 250 years, has swung back and forth. And I think we've seen a little bit more of a swing back in favor of states' rights.
Which is why Dan believes this challenge to federal law has a chance of winning.
But the case law has been pretty clear that the Second Amendment really prohibits any potential impediment to people's ability to own and purchase firearms.
Now, Dan also feels we should think very seriously about putting dangerous weapons in the hands of, quote, peoples whose brains aren't completely developed.